So, friends, coming to the last kind of an aspect for our discussion under Section 23 of the Indian Contract Act is on employment bonds. What this would give you is probably the idea of the coverage of Section 23, the vastness of this section, because you will notice that this is the section that actually covers every other aspect of public policy dimension. So Section 23, friends, is a section that actually clearly gives you the mandate of intervening in unfair contracts or unreasonable contracts on the ground of public policy. So employment bonds is another interesting issue for our discussion today. Employment bond, or what many would see in the market as indemnity bond, it's a contract between an employer and an employee, wherein the employee has to give an undertaking that he will work for the employer for a minimum duration of a time. It could range between 1 year to 3 years to also 5 years, or even beyond that. And this kind of a contract, and or you may say this kind of a clause in a contract, is quite common, and the commonality is not only distinct to private contracts or private employers, it is something that is also visible in public sector employment agreements. Now, the issue on employment bond, friends, arises from the fact that you see over here an employer trying to use his bargain, which is a higher bargaining capacity. He has the right to determine the terms and conditions of employment. So he has some justifications why he should take the bond. For example, one of the justifications for an employment bond is there is high attrition in employment today. So we see a lot of youngsters who, we have this theory called the springboard theory. Springboard? Yes, that's right. Which means an employee joins an employment or his first employer, and he uses it as a springboard. So he makes a jump, he takes a leap and actually joins someone else. So your first employment is just the first window of opportunity to open for you. And hence you will springboard it and actually go on to join rivals or competitors. And hence employers feel aggrieved. They feel, look, we have spent so much of time in recruitment. We have spent so much of time, for example, in a public sector undertaking public recruitment. We have spent time in the recruitment process itself. It could have a process of an examination, an interview, so on and so forth. So we have already selected these candidates. We have invested. And more importantly, once the recruitment process is completed, there is a training that usually some of these employees are given. And there is a lot of money that is invested in training. And sometimes the trainings may range between 1 month to 1 year. And hence, if the employee leaves after all these things have happened, and now he's a ready product to be utilized in a company, if he now leaves and joins a rival or a competitor, that will actually be disadvantageous to the company, to the employer. And hence, employers feel the necessity to have this bond. They feel that it's reasonable to have this bond so that whatever they have done so far in investing on the employee's skill or in his enhancement of his knowledge and training, they feel that the employee is duty bound to work with them for a minimum duration of 3 years or 5 years. This is based also on a justification saying, look, between an employer and an employee, there is a fiduciary relationship. It's a relationship of trust and confidence. It's a relationship of loyalty. It's a relationship that every employee must also have some duty to respect. Secondly, employment bond is also justified by employers saying, look, every employee who joins an organization gets to know a lot of trade secrets. They are having sensitive information. They get access to a lot of price sensitive material. They know the business strategy. They know about the marketing strategy. So a company's trade secret often gets compromised when key employees leave an organization. This affects business. This is advantageous to competitors if a company does not hold back the employee, does not control where these employees go to. And hence, a lot of innovative clauses have been designed today in employment contracts, and this really is a public policy matter. Now, why a public policy matter? Simply because, friends, you know that during Industrial Revolution, there were a lot of labor strikes that took place because it was unfair labor practices by many of these companies and industries. We know that employers and industrialists exploited labor, and that's why you will notice that not only in India but world over, thanks to the interventions of international labor organizations, we have seen a lot of labor movement and labor laws being enacted. These legislations are pro-labor legislations. What did we do? We talked about industrial dispute, we talked about strike, we talked about workers' compensation, we talked about so many other legislations that protect the interest and the rights of laborers and workers. Not only that, labor legislations came into place trying to give social security to laborers as well during employment and post employment, especially when the services are either terminated or when they superannuate or retire. The kind of social security that is required for labor has been provided by various legislations in India as well. So, all the labor legislations are a result of the fact that it is a known factor that employers have a tendency to abuse their bargaining capacity and have unfair trade and unfair contracts with their employees. However, if you look at employment bond in India, friends, the real challenge is where is the grey line of reasonability? Now, you must ask, sir, what does reasonability mean in this case? The reasonability of the contract is, look, once a company which is very large enough and has thousands and lakhs of employees starts making this employment bond to every category of employee, right? Is it something that they should be allowed freely to exploit? That's one question. The second question is, of course, on the term or the tenure of the bond. Now, who decides or who gets to decide whether the employment bond should be for 1 year or for 6 years? Who gets to decide? I think the employers get to decide. But again, the fact is, shouldn't any such tenure or term be reasonable? Reasonable, yes, to the extent of protecting the employer's interest, but more importantly, also to balance the interest of the employees. Now, let us understand that employees feel concerned from employment bond. They feel that their freedom to gain employment, their freedom of livelihood, their freedom of choice, if they wish to change their employer, that choice gets adversely affected by an employment bond. And you know that in the Constitution of India, we have Article 19(1)(g), which says every citizen has the freedom of trade, occupation, and business. While Article 19(2) in the Constitution definitely talks about the fact, yes, there can be reasonable restrictions, and public policy is one of those reasonable restrictions. But here is where probably contractually your freedom gets restricted. Though, when you talk about restriction, you have to evaluate whether the restriction is necessary, to what extent it is too necessary, and to what extent it can be actually tempered down. And hence, public policy in employment, I think it's a very critical factor, and employment bond of the current context are very, very critical, because you will notice that till the courts intervened, the employment bond said something like this. They said, look, an employee has to work with you, with us for a minimum duration of 3 years, and if he wishes to leave within those 3 years, he has to pay 3 lakh rupees. Now remember, the point is this 3 lakh rupees as compensation to be paid in case of the breach of the bond is kind of an exit clause, right? You can escape the bond. So you can escape, but you have to pay 3 lakhs, right? So the employee in turn ends up compensating the employer for his breach of contract to the employment bond. This is like a weapon. It's like a stick. It's like a kind of a warning bell that employers keep with them, so that they know how to enforce employees. They know how to enforce some kind of a loyalty. Now, critics of employment bond have said this is nothing but modern day bonded labor. Yes, they have said, look, the earlier form of bonded labor was a fact where there used to be a iron chain around employees and laborers, and they were forced to work. Bonded labor. Now we have a law on bonded labor. True, it is. But interestingly, if you look at the modern type of bonded labor, the contractual chain binds you for 3 years. They say, look, work for us for 3 years. So it's like a modern kind of a bonded labor. However, with a penalty of saying 3 lakh rupees. But courts again have intervened here, and they have very clearly laid down that look, 3 years and 3 lakh rupees has to also be reasonable, right? Why did you fix 3 lakh rupees? Now, please note, if you read contract law very clearly, this kind of a 3 lakhs, which is supposed to be what we call as anticipated loss, pre-estimated loss, right? It's not the actual loss. It's not, okay, so what's your loss when an employee leaves before 3 years? No, it is not. It is based on some kind of your foresight or calculation. You may say, okay, this is the amount that is spent on recruitment. This is the amount that is spent on training. If not anything else, this is the loss. So it is a pre-estimate. And to a larger extent, you will notice that pre-estimations of losses or damages in contract are called as liquidated damages. This is covered under Section 74 of the Indian Contract Act. Liquidated, right? Liquidated means pre-estimated damages, and the 3 lakh that is exited in employment bond can be considered as liquidated damages. Now, the fact remains that if one applies liquidated damages to employment bond, you will notice that it ought to be reasonable. If it's not reasonable, what you've anticipated, what you've pre-estimated will not be enforced by the courts of law. So the courts have said any kind of exit arrangement in which the employee has to pay to the employer ought to be reasonable, point one. Point two, it has to be proportionate, right? Proportionate because there are possibilities when employees may leave, say, 6 months of the 3-year time, of the bond time. Now, how much should a person who is going to leave after 6 months pay? As compared to how much should a person pay when he at least serves 2.5 years of the bond time of 3 years? Can we say both have to pay 3 lakh rupees? I think that is the reasonability part in actually recovering the kind of compensation that is mentioned in the bond. So the courts are very clear in saying unless the rule of proportionality is applied in the contract, I think the amount that is just blanketly, arbitrarily, one-sidedly mentioned in the employment bond is not going to be enforced or recovered as damages under contract law. But interestingly, if you say it's liquidated damages, then the rule under Section 74 applies. And that's why companies have been very clever enough to design the contract in a manner in which they call it the indemnity bond. To be honest, friends, the distinction here is if you call it employment bond, then Section 74 applies. But if you call it an indemnity bond, then it's a contract of indemnity, and then it gets covered under Section 124 of the Indian Contract Act. Now, indemnity, friends, is also a kind of a promise to cover your loss. So the employee makes a promise to cover your loss. And that's what Section 124 is all about. And it is to say that, look, I will cover your loss. I will cover the risk that may arise from my recruitment, from my hiring. And I will save you from any such loss that may occur due to my early exit from this company. That's an assurance that an employee ought to have given under an indemnity bond, which gets covered under Section 124. Now, please note the wordings of the clause may be the same, but the title, once it is indemnity, gives the employer a wider right, a broader right to cover and recover many things that cannot probably be done so under Section 74. So the interesting part is, friends, indemnity gives you the right to not only cover, the damages per se, but you can also cover costs. You can cover any other indirect loss that you may occur due to the loss of the employee. So instead of just saying it is covered as a normal contract, the employers prefer to call it indemnity contract simply for the fact they feel the broader aspect of the right to recover in indemnity is advantageous to them as well. So I think you will notice that a strategy is adopted over here because in the law of damages, there is reasonability. In the law of damages, there is this rule of remoteness. So you cannot cover remote damages. In the law of damages, there is this proportionality rule that has come into place. And hence, there is disadvantages there. And hence, call it indemnity, cover it under a different section of the Indian Contract Act so that you can get broader rights. You can get actually indirect losses. And this would rather make the employee far more accountable and liable for any kind of a breach of the bond, and the enforceability of the same becomes far more effective. And that's why companies and contract lawyers call the employment bond as an indemnity bond. I think with that, we should be able to kind of close Section 23. It's been a kind of a detailed discussion on Section 23, which are agreements that are void, unenforceable, which are those that are against public policy. Where can the contract be intervened through the courts of law? Why should the courts intervene and evaluate some of these agreements and contracts? I think we have created a lot of discussion on this part. Friends, moving on to understanding void agreements in a much more detailed fashion. So, as prescribed by the Indian Contract Act, we will come across sections including the section of Section 26, which says agreement in restraint of marriage is considered to be void. Friends, Section 26 is about a section which says, look, you don't expect contracts and agreements to be made that will affect the right of people to get married, and restraining someone's choice to get marriage is void. Now, this is probably, we don't have a modern contemporary case law to explain Section 26. But, something like, say there is a contract between two widows. Say they have lost their husband, and these two widows make an agreement saying that, look, if either one of us gets married, then we will lose our right over our deceased husband's property. Now, one of them decides to get married, right? And she will lose her, succession right to her first husband's property. Now, such kinds of agreements have been evaluated by the courts to see whether it attracts Section 26, because, it's in restraint of marriage. It probably is an agreement that tries to stop you from marrying the second time. Does it stop you? That's the question. Because, see, the point is, once you are going to marry for the second time, you can inherit your second husband's property. So, is it fair that the continuing widow gets to keep the entire property of the first deceased husband? Or should this agreement be treated as in restraint of marriage? Friends, restraint of marriage means that an agreement probably restrains you from going and getting married. So there is a promise saying I won't get married, and hence this is a contract, this is an agreement, right? So I think the drafters of the Indian Contract Act very clearly had to say this, that marriage is a personal choice of parties. There should not be any contract that restrains such personal choices. So commercial agreements and contracts have no business to enter into the choice of marriages. That's probably the message that comes from Section 26. However, friends, if you have to just evaluate in contemporary times an agreement called the prenuptial agreement, then it could be quite appropriate for us to discuss the same under two sections of the Indian Contract Act. First is Section 23. That is agreements opposed to public policy. Second is, maybe it's an agreement in restraint of marriage. I'm not sure. Maybe we'll have to evaluate, because prenuptial agreements is about your marriage rights. Now, one clearly understands and knows that there are three sides in a story of marriage. Marriage itself, because we have seen whether a marriage is a contract. See, the point is, marriage can look like one, because there is an offer, there is an acceptance, there is consent in marriage. The definition of, say, fraud under the Indian Contract Act and the Hindu Marriage Act seem to be almost similar. So marriage can probably look like a contract, but you will notice that once special legislations were enacted, like the Hindu Marriage Act, the Muslim Marriage Act, and Christian, and so on and so forth, then marriage is governed under those special laws, and it need not be covered under the contract law, right? So divorce is not considered breach of contract. So marriage is outside the domain of contract law. Similarly, you will notice post-marriage, say there is a divorce, then can there be some kind of a settlement agreement between husband and wife for maintenance? Now, we know that such kinds of arrangements between husband and wife for, say, maintenance, for other formats, can be agreement enforceable at law, right? So there can be a mediation, and there can be a settlement agreement, and it can be made enforceable at law. So there are some elements of contracts that can be brought in to post-marriage arrangements. Now, prenuptial agreement, friends, is before marriage. Now, in the United States or even in the Europe and in UK, it is quite a common practice among celebrities to have prenuptial agreements. In the United Kingdom, there have been some very interesting cases of prenuptial agreements and the challenges of its enforceability. Now, while prenuptial agreements exist in US, UK, and Europe, the question in India is, can we consider any of these as enforceable? Because there is a lot of sanctity that is involved with marriages. There is a lot of religious and customary practices that govern marriages, and hence the challenges is should it be governed under the Indian Contract Act. Now the point is, marriages are spiritual. They can be attached with religion, or it can be under the Special Marriage Act as well. You can go and register in marriage. But we think that it is a social life or social circumstances. But before that, can the husband and wife or the parties and the partners to a marriage have something called a prenuptial agreement? I believe that this is possible. It's nothing but a partnership. It is nothing but a kind of an arrangement that the parties would want to make before marriage, because there are advantages of prenuptial agreements. Clearly, the advantages are the prenuptial agreement. Look, it may anticipate breakdown of marriage. So for many of us, it may look like there is a distrust, there is a mistrust that is already created by making such an agreement. But that is the job of contract. The job of contract is to anticipate risk and to say that in case there is breach, these are the liabilities and these are the obligations between the parties. So contract is for that. If you actually have an absolute trust, then you don't need a contractual document, isn't it? We think that the trust will go on, that will last, but unfortunately, in case it does not, then the contractual provisions will apply, is the reason why contracts are made. And I think the same justification applies to a prenuptial agreement. Now, prenuptial agreement, friends, according to, say the positions in common law, are very much valid and enforceable. Clearly, it has advantages because, say two celebrities, they have their own property that they have made before marriage, right? And, their intention is very clear that they don't want to merge the assets and properties that they've made before marriage as matrimonial property. They don't want to merge it after marriage. So they want to keep it separate. Now, after marriage, whatever property and assets and cash or whatever they flow, that will be considered as a matrimonial property, which both the parties will have equal share. So wherever there is this anticipation saying, look, let's keep our properties before marriage separately, we don't want the other spouse or the partner to have any share in it, a prenuptial agreement actually works pretty well in those circumstances, because breakdown of marriage is some kind of a purpose that people can definitely anticipate as they go forward. And we have seen that with various celebrities, politicians and others who have undergone divorce, the immediate rescue part has been the prenuptial agreement that has come into place. Also, prenuptial agreement, what it does is it kind of restricts the discretion of the judges in deciding issues of maintenance and so on and so forth. Now, maintenance, if it goes to the judiciary and to the judges, they will actually go by, say, 50% of the salary, 50% of assets, so on and so forth, as the principal rule, because I think whatever is earned by the husband or by the, by the earning member in the partnership, I think they have a duty to actually share the same with the other partner. Now, prenuptial agreement can actually look at it from a very interesting perspective, trying to cap that kind of maintenance that the judges would want to decide. Right? So the maintenance may be agreed at, say, 30% of the last drawn salary, or it could be a lump sum alumni that has to be granted. So alumni is a lump sum amount. Maintenance is probably a regular kind of payout. Even the Indian courts today don't give maintenance, because that's a continuous kind of a duty and an obligation that has to be monitored by the courts of law. Sometimes it may be difficult to even enforce it. So one-time alumni payment is what is generally the court's insistence even in India. Prenuptial agreements also deal with issues of custody of children. Now, when divorce occurs, it's important that the best interest of the child be taken care. That's the principle in India. And in India, that a child less than 5 years, the best interest of the child is with the mother. And after the 5-year rule, then it depends upon the economic and social conditions of the partners and about who the child should be with and who has the responsibility to take care of the child's education and meeting other expenses as well. A prenuptial agreement can actually bring in clarity on those aspects as well. And finally, prenuptial agreements are very clear on division of property and assets between the partners, and hence, I think the agreement has been found to be quite useful. The judges have just implemented the provisions of the agreement whenever divorce has taken place, and hence, divorce is faster, it's easier, and it's far more clear when it happens, especially in Western countries. Now, coming back to India, friends, there are so many things that are attached to prenuptial agreement that we think it may not be enforceable in India. The arguments are that, look, in India, the situation is such that the legislature has drafted key legislation to protect the rights of women in marriages. There are key legislations. For example, we have a legislation that grants and guarantees maintenance to women in marriages. And we know that even in Muslim marriage, such kind of maintenance has been a legislative kind of a mandate, and hence maintenance is a part of a statutory right. Now, please note, as discussed in section 23, anything that is forbidden by law, anything that defeats the provision of any maintenance law, cannot be what is prescribed under the prenuptial agreement. If it is done so, the prenuptial agreement will be opposed to public policy. Right? So the public policy means women have right to maintenance, statutory right to maintenance. Prenuptial agreements cannot abdicate that right. It cannot waive or diminish those rights. Similarly, friends, in terms of, say, divorce, we have clear regulations as regards child custody, child maintenance, so on and so forth. Again, prenuptial agreements have to be in tandem to the statute and to the provisions of law. So anything that the law assures to a child, to women, a prenuptial agreement will have to adhere to those kinds of statutes and law. And in case it is not adhering to the same, we will notice that the prenuptial agreement will be opposed to public policy under section 23. So I think, my position would always be that prenuptial agreements can be made enforceable in India by keeping the statutory rights and provisions in place. And if parties still desire to have one, such an agreement can be drawn, and it can be drawn so as to not attract void agreements. It can be drawn to ensure that the parties can make this agreement as an enforceable one, keeping the public policy, public interest, and statutory provisions that exist in India, which I think are not only unique, but they are something that the country should adopt furthermore as a social security provision for vulnerable communities and individuals. And contract law has to respect those kinds of rights, and anything that waives, extinguishes, diminishes those rights are definitely something that we can oppose and hold it as being opposed to public policy.